So first of all, I am absolutely overwhelmed and excited by the response of people coming to this talk tonight. It gives me, it makes me really happy to see people are interested in this issue, want to learn more, and hopefully after hearing this panel, you'll be as worked up about this issue as I have been in the last several months. I just want to say a quick thank you to Beth and the Center for hosting this event and all of those that were involved in putting this together. I'm very excited about this. So Beth raised an important question which I want to throw out to you all as I start to talk about this topic, which is, should rap lyrics be used in court as evidence of a crime? And later this week, the Supreme Court of New Jersey is going to hear a case that will help decide just that. At issue is a prosecutor's extensive use of rap lyrics composed by a man named Vontae Skinner as evidence of his involvement in a 2005 shooting. Now, during Mr. Skinner's trial in 2008, a prosecutor read to the jury 13 pages of his violent rap lyrics, even though all of the lyrics were composed before the shooting had occurred, in some cases years before, and none of them mentioned any of the specific details about the crime or the victim. So there was no correspondence between his raps, his lyrics, and what had happened in the particular case. Other evidence against Mr. Skinner was very thin. It was largely testimony from eyewitnesses who later recanted or changed their story. And yet the jury found him guilty of attempted murder, and he was sentenced to 30 years in prison. But in 2012, this conviction was overturned by an appellate court, which ruled that the lyrics should never have been admitted as evidence to begin with. This is what the majority opinion stated, quote, "We have a significant doubt about whether the jurors would have found defendant guilty had they not been required to listen to the extended reading of these disturbing and highly prejudicial lyrics." Now, the state appealed the ruling to the Supreme Court, which brings us to where we are today, with the New Jersey Supreme Court hearing this case this week. Now, Mr. Skinner's case is far from unique. Rap lyrics are turning up as evidence in courtrooms across the country with what we call alarming regularity, as my co-author Eric Nielsen and I talk about in our paper, which is forthcoming in Race and Justice. Rather than treat rap lyrics as an art form whose primary purpose is to entertain, prosecutors have become adept at convincing judges and juries alike that the lyrics are either autobiographical confessions of illegal behavior or evidence of a defendant's knowledge, motive, or identity with respect to the alleged crime. We argue, though, that putting rap on trial has significant implications for how we define creative expression, as well as for free speech and the right for all Americans to receive a fair trial. So in the short time I have today, I want to do two things. First, I want to offer some examples of recent cases in which rap music has been used as evidence in trials against amateur rappers, nearly all of whom have been young men of color, in order to illustrate the ways in which the prosecutors use rap, as well as highlight the devastating effects it can have on defendants. And that's suggested here in my title, which is a line out of Mobb Deep's song, "For Every Rhyme I Write, It's 25 to Life." They're referring to, Mobb Deep is referring to here 25 years or life in prison. And secondly, I want to describe elements of rap music that we argue leave it vulnerable to judicial abuse, as well as discuss the artistic, racial, and legal ramifications of using this particular genre of music to put people in jail. Now, although the use of rap lyrics as evidence in criminal trials is a relatively recent phenomenon, we discuss how it resides within a large or long tradition of antagonism between the legal establishment and hip-hop culture more broadly, one that can be traced back to hip-hop's earliest roots. And Sohail will probably have comments along these lines. But in this context of antagonism, we argue that a new battle to criminalize rap music in the judiciary is emerging. Examples abound, but because of the short time I have today, I'll just give you a few. In 2006, rap lyrics constituted a recurring sidelight of a trial that involved Ronell Wilson, a young African-American man charged with killing 2 undercover detectives in Brooklyn. When the police arrested Wilson the day after the detectives were shot, they found scraps of paper in his pocket with handwritten violent rap lyrics. You can see the picture here of what they found. The prosecutors claimed that these lyrics amounted to a confession that were written after the shooting. Wilson's attorney countered that many men in their early 20s, especially aspiring rappers, compose violent rap lyrics and that such lyrics reflect boastful fantasies. Despite these claims, the prosecutor's lyrics as confessional argument was persuasive, and Wilson was ultimately found guilty and the jury sentenced him to death. In April of this year, Anthony Johnson of San Antonio, Texas, was charged with the murder of his business partner, Romuald Rodrigue Nagande. Johnson, who was characterized as a wannabe San Antonio music Mongol, and Nagande, his music producer, had an ongoing dispute over the management of their hip-hop record label. On the day of the murder, the two had been arguing when Johnson, pictured here, claimed that he shot Nagande in self-defense. Now, while he was in jail, he penned some rap lyrics, which were eventually seized by prosecutors and used against him in his trial. Johnson's attorney argued that we shouldn't imbue these lyrics with any real meaning. They were just written while he was in prison, passing the time away. And we find out from the case that they helped convict Johnson of murder. He's now facing life in prison. Now, Wilson and Johnson's dilemmas are characteristic of many cases involving rap lyrics in criminal trials, where prosecutors attempt to portray lyrics as an accurate depiction of past behavior, right? This is what happened. Or they reflect criminal dispositions. This is the character argument. But a more sinister tactic, however, involves criminalizing the lyrics themselves. And nowhere is this more evident than in the case against Olutosin Oduwole, an aspiring rapper whose rap lyrics alone were deemed so threatening and such a danger to the public that he was charged with attempting to make a terrorist threat. This case was so unsettling in the criminalization of rap lyrics that it independently attracted the attention of my co-author, Eric Nielsen, and myself, and became the catalyst for our collaboration, this paper and the presentation today. Let me give you a little background. In 2001, I was contacted by a lawyer who had come across a paper of mine titled Gangsters, Thugs, and Hustlers, The Identity and the Code of the Street in Rap Music. And this paper was written based on a content analysis I had performed on over 400 gangster rap songs. And the lawyer was interested in knowing if I'd be willing to serve as an expert witness on a case involving his client, Olutosin Oduwole, whose stage name was Tosin, who was at the time charged with making a terroristic threat. What happened is in 2007, Oduwole's car ran out of gas, forcing him to abandon it on the Edwardsville campus of Southern Illinois University, which is where he was attending school. When school authorities found the car, they also found a piece of paper in Oduwole's console of his car, which came to be referred to as the note during the trial. Now, on one side of the note, you can't read this, but what everyone agreed with was Oduwole's rap lyrics. He was an aspiring rapper. This is his handwriting. This is actually instructions on how to use an inhaler. So he just jotted down some rap lyrics that he had come up with. And then on the other side of the note were also rap lyrics at the top there, okay, followed by 6 lines of text at the bottom right here, upon which the entire case rested. Now, the state claimed that these 6 lines of text represented a terrorist threat. Oduwole and his lawyers claimed that they were in fact the beginning stages or ideas for a rap song. They were in fact the beginning stages of the lyrical process in creating rap music. Now, you can't read them, but I'll sort of paraphrase here. There's a reference to a PayPal account followed by, if this account doesn't reach $50,000 in the next 7 days, then a murderous rampage similar to the VT shooting will occur at another highly populated university. This is not a joke. Now, with very good reason, the police officers immediately got a search warrant to search Oduwole's apartment, where they found notebook upon notebook filled with Oduwole's violent rap lyrics that he himself had penned, okay, along with some guns that he had purchased legally, but because it was on campus, they were not allowed. They combined these 2 sets of evidence and charged Oduwole with terrorist threat. 4 years later, he went to trial. As an expert witness, the attorneys asked if I would review the evidence, which included these spiral-bound notebooks of lyrics, and provide my opinion on these 6 lines of text. And I agreed, and after months and months of doing a content analysis of these lyrics, I produced a lengthy report, which I submitted to the court, and then was called on to testify. Now, during my testimony, I did lots of things. I first described to the jury what rap music is, particularly the subgenre of gangster rap. I then showed evidence that indeed Oduwole was an aspiring rapper, and not just any kind of rapper, but a gangster rapper. I explained to the jury why violence is so prevalent and commonplace in gangster rap. I talked about things like gaining respect within the rap community, the artistic conventions associated with gangster rap, selling records, these sorts of things. I then argued it was predictable that Tosin's lyrics themselves would be extremely violent and that the themes identified in his lyrics would mirror what I had identified in my content analyses of more popular gangster rap music, things like portraying a violent identity, violent threats, the glorification of guns, etc. Finally, I testified on the lyrical process involved in creating rap music, noting that lyrics can reflect different stages of creative development, therefore they don't always rhyme, they don't always make exact sense, they're not fully polished, okay? And I also talked about a technique that rappers often use called intros and outros, which are either the beginnings, the introductions to songs or the ending of songs, which are often unrhymed, but sort of emphasize the point of the song. They set up the song or they conclude a song with a punchline, if you will. And in making each point, I offered numerous examples from Tosin's notebooks to support the points I was making, and I reached my final opinion, that in fact the 6 lines of text could reflect initial ideas or concepts from a rap song, or they may constitute an intro or outro to that song. Well, jury was not convinced. After deliberating less than 3 hours, they declared Tosin guilty. He was sentenced to 5 years in prison. Now, since then, the criminalization of rap lyrics has continued, and in fact, it has increased in many ways. In our paper, Eric and I discussed numerous examples that I could share with you, but because I don't have time, and Beth is limiting us, and I know she is, I don't have time to talk about today, but the point that I want to say here is that this is not an isolated practice. In fact, a number of indicators suggest that the practice is on the rise. First, we see an increasing number of cases reported in the media. In fact, Eric and I are currently collecting these cases. We have Google searches, we're reaching out to people. We are creating a database of cases, if you will, where this is happening. We're in the dozens at this point. Secondly, we see more and more news articles with titles such as "More Rap Lyrics Showing Up in Court." Third, we're beginning to see a growing number of commentaries on this topic by academics. And finally, there's the recognition among some prosecutors that this tactic is effective. So effective, in fact, that they have begun promoting it. A recent training manual produced for the National District Attorneys Association advises, quote, that through photographs, letters, notes, and even music lyrics, prosecutors can invade and exploit the defendant's true personality. Now, while the exact number of cases that involve rap lyrics as evidence is unknown at this point, what is less debatable, we argue, is the potentially harmful impact this practice may have. So in the remaining few moments that I'd like to discuss the implications of putting rap on trial. The movement to criminalize rap music, we argue, reflects a broader effort to redefine the meaning of rap music. Rather than treating rap as an art form, whether you like it or not, whether you find it offensive or not, or misogynistic or not, rather than treating it as an art form whose primary purpose to entertain, prosecutors argue that the lyrics are either autobiographical confessions of illegal behavior, we call this the lyrics as confessional argument, or evidence of the defendant's knowledge, motive, or identity with respect to the alleged crime, and we refer to this as the circumstantial evidence argument. Especially noteworthy is that rap is the only genre to be treated this way in the court system. Andrea Dennis, who's a legal scholar, wrote a great piece on this topic. She did an analysis of all the legal cases where defendant-authored lyrics were used against them in court, and out of all the cases that she could identify, only one was not a rap lyric. This problem, from our standpoint as scholars who study rap music, is that the fictional characters portrayed in rap songs are often a far cry from the true personality of the artists behind them. The near universal use of stage name among rappers is the clearest signal that rappers are fashioning a character. Yet the first-person narrative form and rappers' frequent claims that they are keeping it real lends themselves to easy misreading by those who are unfamiliar with rappers' complex and creative manipulation of identity, both on and off stage. This is particularly problematic with the subgenre of gangster rap, where artists take on a criminal persona and offer embellished, often extremely graphic accounts of violence, sexual conquest, and other illicit activity. If audiences don't appreciate that these are genre conventions, they can conflate artist with character and fiction with fact. But they are indeed genre conventions. While one can certainly find isolated examples of rappers with real-life connections to crime, which is true of any art form for that matter, it would be a mistake to extend this generalization to rappers more broadly. If rappers were guilty of even the tiniest fraction of the violence they project in their music, we'd all be in big trouble, a point that Eric and I have stressed in our work and have explained to jurors while testifying. Unfortunately, judges and juries do not always understand this, an ignorance that prosecutors either share or gladly exploit. In case after case, the results have been devastating for the accused, and research by social scientists helps understand why. For example, in one study by a social psychologist, Charis, she devised an experiment in which she presented two groups of subjects with lyrics, violent lyrics, excessively violent lyrics. And one group she told, these are rap lyrics. And another group she told, these are country music lyrics. And as she hypothesized, the responses to the lyrics were significantly more negative when the lyrics were represented as rap than when they were represented as country music. And the responses to the lyrics were quite different depending on the genre associated with it. There's an important racial dimension here that I'm sure you already obviously see, which is country music is traditionally associated with white performers, rap, young men of color. So here's where a critical implication of putting rap on trial begins to surface, we argue. In these trials, authorities are often prosecuting young men of color, or a young man of color, someone who already looms as a threatening stereotype in the minds of society. Using rap lyrics as evidence, then, is not just a matter of art being sacrificed for the sake of an easy conviction. Rather, the practice also constitutes a pernicious tactic that plays upon and perpetuates enduring stereotypes about the inherent criminality of young men of color in this country. The lyrics must be true, it follows, because what is written fits with what we know about criminals. That is, where they come from, what they look like, etc. Finally, putting rap on trial also raises serious questions about the equal application of our First Amendment protections, something I'm sure Dean Chemerinsky will enlighten us about. After spending over a year in jail, Olutosin Oduwole was released after the District Appellate Court threw out his conviction. In an interview shortly after, he lamented, "I still continue to make music, but now I'm a bit more aware of what I'm writing, making sure everything stays away from violence." Oduwole's comments speak to the potential chilling effect of putting rap on trial as more and more aspiring rappers find themselves locked up for their lyrics. In such a climate, we are left with a freedom of speech that comes with caveats, or, as rapper Ice-T famously put it decades ago, freedom of speech, you better watch what you say. Thank you.